5 minutes. That's all the time I had to secure the most powerful legal protection against my HOA. The state attorney general was sitting right there, across my vintage wooden table, reviewing a mountain of evidence that could finally expose the board's abuse. But just as he nodded, a shadow fell over the front window. The door didn't knock. It simply flew open, and HOA Karen charged into my remote cabin, ignoring everything but her rage. She was there to fine me for my untrimmed pines, unaware she was about to commit the single biggest mistake of her miserable tenure. What happens when petty tyranny collides with the highest legal authority in the state? You won't believe it. My name is Alex, and for 3 blissful years, my home wasn't just a house. It was a retreat carved into the landscape. We're talking about a small, exclusive community nestled deep in the Shadow Creek Valley, a place where the air smells of pine and cool granite, and the only traffic jam is a herd of deer crossing the private road. It was a lifestyle, not just a property. The place itself was a custom-built, timber-frame cabin. I bought it specifically for its remote feel and its glorious year-round access to natural light. Its best feature wasn't the vaulted ceiling or the stone fireplace, though. It was the sense of absolute peace that settled in the moment you stepped inside. This peace, however, was conditional, dictated by a thin binder of covenants overseen by the Shadow Creek Homeowners Association. The community had a reputation for being hands-off, largely because the properties were so spread out. We were on the edge, practically the last house before the protected wilderness area. This seclusion was exactly why the Shadow Creek HOA was supposed to be toothless, a mere formality for road maintenance and gate repairs. The trouble didn't start with a bang. It started with a single, pristine white envelope delivered to my mailbox. It was a letter from the newly elected HOA board president, a woman we'll call Patricia. She had only moved in 6 months prior, trading her manicured suburban lot for the valley, and she brought with her a passion for uniformity that bordered on obsession. Patricia was the kind of person who saw the wild, natural beauty of the valley not as an asset, but as a liability. She viewed the random growth of native grasses and the untouched rock formations as unapproved landscaping. She believed the community needed to be elevated, which, in her mind, meant transforming a rustic haven into a cookie-cutter development. The letter was a notice of non-compliance regarding my property's boundary markers. It was petty, tedious, and easily dismissed at first. I figured a quick email explaining the markers were buried beneath natural overgrowth would suffice. I was wrong. The ensuing flurry of demands, each one more absurd than the last, culminating in a threat over my perfectly healthy, but too tall stand of lodgepole pines, revealed that Patricia wasn't just enforcing the rules. She was weaponizing them. It quickly became clear that my quiet, secluded life was the next target on Patricia's agenda. She couldn't stand the sight of anything that wasn't perfectly controlled, and my wild, beautiful cabin on the perimeter was the biggest offense. The stakes were no longer about fines. They were about defending my right to live in my own home without constant, invasive scrutiny. I needed to fight back, and that decision set me on a collision course with Patricia that would eventually bring me face-to-face with the state attorney general himself. The single white envelope had been a warning shot, but what followed was a full-scale siege. Patricia, having failed to intimidate me with her initial petty demand, escalated her campaign with an almost unbelievable speed and ferocity. She didn't just want me to comply. She wanted to punish the very idea of nonconformity that my secluded cabin represented. My email, a perfectly polite explanation that my boundary markers were simply obscured by the kind of native, low-lying brush that was common to the valley, was met not with a reply, but with a certified letter. This time, the fine was $250, accompanied by a new, more sinister ultimatum. I had 7 days to remediate the unauthorized overgrowth along the entire 1,000-foot perimeter of my lot, or the fine would double, then repeat weekly. This wasn't just about a few bushes. The covenants, which I meticulously reread, stated that the HOA was only responsible for maintaining the common aesthetic of the front-facing view from the street. The rest of my property line bordered the pristine forest, land that was explicitly protected from clear-cutting by county ordinance. Patricia wasn't just abusing the rules. She was demanding I break the law to satisfy her manicured vision. The helplessness was the worst part. I felt this creeping, suffocating sense of being watched. Every time I stepped out to check the mail, I imagined her little sedan parked somewhere on the hill, binoculars aimed at my windows, meticulously documenting the crimes of my natural landscape. The peace that had defined my life in Shadow Creek was now poisoned by paranoia and paperwork. I fired off my first professional counterattack. A carefully worded letter from my local property attorney, citing the county's environmental protection statutes. The law was clearly on my side. I felt a fleeting sense of relief. Surely, a letter from a legal firm would be enough to make Patricia pause, to realize she was out of her depth. But Patricia didn't pause. She retaliated. A week later, I received not one, but 3 envelopes. The first was a notice stating my attorney's letter was frivolous and inflammatory, and the weekly fine had been tripled to $750. The second was a new citation, entirely unrelated to the first. A fine for an unapproved color choice on my front door. The door was the original, natural stained cedar that the builder had used, perfectly matching the required rustic palette. Patricia claimed, without evidence or board approval, that the color was too dark and cast a depressing shadow on the community. The third envelope, however, hit me with a jolt of genuine fear. It was a formal notice of lien intent. This meant Patricia, leveraging her unilateral control over the board's finances, was threatening to place a lien on my property. A clear step toward foreclosure. All because of the color of my door and the natural growth of my trees. This was no longer petty neighborhood squabbling. This was an outright, calculated attempt to force me to sell or surrender my home. This was the point of no return. The financial pressure was significant, but the emotional drain was devastating. I was spending all my evenings poring over county records, architectural review board meeting minutes from a decade ago, and every line of the dense, confusing HOA covenants, trying to find the one fatal loophole in Patricia's armor. The stress manifested physically. I became withdrawn, focused only on the next step in the legal chess match. I started sleeping in my office, surrounded by stacks of legal documents, feeling a profound sense of violation that transcended the financial threats. This cabin, my sanctuary, had been invaded by an unseen, bureaucratic enemy. My investigation led me down a dark, convoluted path. I found inconsistencies in the HOA's annual financial reports, small, odd disbursements for board administrative costs that dramatically spiked right after Patricia took over. I also found something more promising. A technical error in the filing of the original HOA master declaration with the county clerk decades ago. It was a needle in a haystack error that might, invalidate the entire document under state property law. It was an extremely long shot, a legal nuclear option, but I had to pursue it. I contacted a specialist property rights lawyer an hour away. He reviewed my mountainous case files, saw the egregious overreach, the obvious malicious intent, and the county ordinance violations. He agreed that the rules themselves were absurd, particularly the new one Patricia had tried to push through regarding visible satellite dishes. A change that would have effectively cut off dozens of homeowners from high-speed internet. The lawyer explained that Patricia was operating with a dangerously unchecked level of power, and local court battles would be slow, costly, and emotionally draining, essentially allowing her to win by attrition. He presented the true nuclear option, escalating the issue directly to the state level. He knew the Office of the State Attorney General had a growing interest in cracking down on abusive HOA practices that trampled on fundamental property rights, particularly in areas where HOAs operated like unchecked private governments. The lawyer set up a preliminary consultation for me. A private, high-stakes meeting with a senior deputy from the Attorney General's office, scheduled for 11 a.m. on a Tuesday. The deputy's name was Mr. Harrison, and he agreed to meet me not in his downtown office, but at the cabin itself. He wanted to see the infamous non-compliant property and the adjacent wilderness area with his own eyes. This meeting was everything. It was my one chance to bypass the soul-crushing local bureaucracy and bring the full weight of the state down on Patricia's reign of terror. I spent the entire previous day meticulously organizing every fine, every threat of lien, and every county ordinance violation into a single, cohesive narrative. I cleaned the cabin, determined to present myself as the wronged, responsible homeowner that I was. I just needed 1 hour uninterrupted to lay out the case. Mr. Harrison arrived precisely on time. He was quiet, meticulous, and instantly focused. I began to walk him through the timeline, pointing out the absurdity of the too dark door and the impossibility of clear-cutting the protected brush. He was taking careful notes, his expression shifting from detached professionalism to slow, steady indignation as I presented the illegal lien intent notice. I could feel the momentum swinging. This was it, the beginning of the end for Patricia's petty tyranny. Then, just as I was showing him the aerial photos detailing how Patricia's demands would force me to violate county environmental law, my heart seized in my chest. I heard the unmistakable screech of tires on the gravel road outside, followed by the sound of a car door slamming with aggressive finality. A colossal, dark shadow suddenly filled the large front window, blocking the glorious light that was supposed to represent my peaceful escape. Patricia. She was here, and she didn't look like she was stopping for a chat. The cabin door didn't just open. It was flung inward with a sickening crash against the interior wall. The quiet, professional atmosphere that Mr. Harrison and I had built, the precise, legalistic review of facts and evidence, shattered instantly. There stood Patricia, eyes blazing, framed against the serene backdrop of the valley she sought to control. She was wearing a perfectly pressed polo shirt and a look of absolute, unshakable certainty. Her face was a mask of furious indignation, honed by months of micromanaging homeowners. She was here for a final, humiliating victory, completely unaware of the actual company I was keeping. "Alex, I knew I'd find you hiding out here." Her voice was shrill, amplified by the high ceilings of the cabin, and entirely devoid of the quiet civility this setting demanded. "The truck you had delivered this morning, the oversized, unauthorized commercial vehicle. It's a clear violation of Section 4.c of the new amendments. I've already contacted the tow company. You have exactly 30 minutes to move it before I place the final lien for $1,500 on your property." She didn't see Mr. Harrison. Her vision was locked on me, fixed on the documents scattered across the table, too consumed by her own manufactured authority to notice the large, impeccably dressed man sitting quietly to my right. I stood up slowly, trying to project calm, while my heart hammered against my ribs. This was the peak of her abuse, a raw, naked display of her absolute belief that she was untouchable. The urge to yell, to match her fury, was overwhelming, but I knew I had to maintain the quiet professionalism that Mr. Harrison represented. The power in this room was no longer mine. It belonged to the state. "Patricia," I said, my voice deliberately low and even, a jarring contrast to her yelling. "I think you need to leave. I'm currently occupied with a private consultation." She laughed, a harsh, barking sound of disbelief. "Consultation? With who, Alex? Your landscaper? The one who's supposed to be clearing that ugly brush? This is an official HOA matter. You're accruing daily fines, and I have the absolute right to enforce the covenants right now. I have pictures of the front door. I have pictures of your untrimmed pines. I have pictures of this truck. I'm serving you notice of immediate compliance right here, right now, and if you touch this piece of paper I have right here, it counts as acknowledgement." She took a menacing step toward the table, reaching out to slap a brightly colored yellow fine notice directly onto the documents in front of Mr. Harrison. It was a move so audacious, so utterly disrespectful of my private space and my attempts at professionalism, that it was breathtaking. It was in that precise second that Mr. Harrison finally, slowly, turned his head and looked at Patricia. He didn't speak. He didn't even stand up. He simply extended his hand, picked up the yellow slip of paper that still had Patricia's fingerprints on it, and placed it neatly on the corner of the table. The silence that followed was deafening. It was the silence of pure, petrifying shock. Patricia had stopped dead in her tracks, her mouth slightly ajar, finally registering the presence of the powerful, professional stranger. Her eyes darted from Mr. Harrison's tailored suit to his stern, unamused face, and then down to the small, leather-bound wallet he held in his other hand. Mr. Harrison opened the wallet just enough to reveal a glimpse of the official seal and his photo ID. His voice, when it finally cut through the air, was calm, measured, and carried a weight that Patricia's hysterical shrieks could never possess. "Ma'am," Mr. Harrison said, his eyes drilling into hers, "I am Deputy Attorney General Thomas Harrison. I am here conducting an official, confidential inquiry on behalf of the State Attorney General's office regarding potential violations of state, nonprofit corporation codes and property rights statutes by the Shadow Creek Homeowners Association." Patricia's face drained of color. The furious, self-righteous pink of her cheeks turned a sickly, ash gray. All the adrenaline, all the petty power that fueled her intrusion, evaporated instantly. She had gone from the queen of her little suburban kingdom to a criminal suspect in the presence of the law. She stumbled back a step, knocking against the open door. You can't be here," she stammered, the words barely a whisper. "This is private property. An HOA matter. You don't have jurisdiction." Mr. Harrison simply raised an eyebrow. "On the contrary, ma'am, state statute grants my office full authority to investigate documented patterns of abuse, negligence, and malicious enforcement practices within nonprofit corporate entities operating within this Commonwealth. And you," he continued, leaning forward slightly, his tone becoming sharper, "have just provided what appears to be a very compelling, very public, and very well-documented example of the hostile conduct that forms the core of this inquiry." He gestured to the pile of evidence on the table, the lien intent notice, the frivolous fines, the threats to violate county environmental law. Then he tapped the new yellow fine notice she had just thrown onto his workspace. "We have been reviewing threats of immediate lien and potential foreclosure against Mr. Alex based on unapproved and arguably illegal amendments, such as the one concerning the satellite dish. You just personally entered Mr. Alex's home, uninvited and aggressive, to issue a $1,500 fine over a truck that is clearly marked for his contractor, who is here today to begin the court-mandated preservation work on the original cedar door color you arbitrarily deemed too dark. Furthermore, you did this while attempting to obstruct a state official's investigation." The reality of the situation hit Patricia like a physical blow. She wasn't just losing the battle. She had walked into a legal ambush broadcast in high definition. She saw her entire fragile structure of power collapse in a matter of seconds. The realization that her most explosive act of petty tyranny had occurred directly in front of the very person assigned to dismantle her was a humiliation that was absolute. She didn't try to defend herself. She didn't offer an excuse. She simply stumbled out the door, her composure shattered, the perfectly pressed polo shirt and the aggressive slamming of the car door on her retreat becoming a final, frantic sound of defeat and terror. The room fell silent once more. Mr. Harrison calmly picked up the fine notice and added it to the growing stack of evidence. He looked at me, a flicker of something close to amusement in his eyes, before his professional mask settled back into place. "Well, Alex," he said, tapping the documents, "that was certainly illuminating. I believe the state name now has everything it needs to move forward." The moment Patricia's sedan disappeared down the gravel drive, kicking up dust in a frantic wake of shame, the atmosphere inside the cabin changed entirely. The air, which had been tight and charged with adrenaline, suddenly felt breathable again. It wasn't the relief of winning a skirmish. It was the visceral, overwhelming realization that the shackles of constant surveillance had just been violently broken. Mr. Harrison, the Deputy Attorney General, took his time. He didn't rush the moment, allowing the silence to settle and absorb the enormity of the confrontation. He simply nodded, closing his notebook with a decisive snap. The yellow fine notice, Patricia's final, desperate act of petty aggression, was now categorized evidence. It was the physical proof they needed, the perfect closing scene to the narrative of abuse. He hadn't just observed the violation. He had personally witnessed the malicious intent and the contempt for due process that had characterized Patricia's entire term. Within 48 hours, the machinery of the state began to grind. It was a swift, overwhelming legal action that no volunteer HOA board was equipped to handle. The first strike came as a cease and desist order served directly to the Shadow Creek HOA's registered agent, Patricia. This order wasn't a warning or a suggestion. It was a legal command that immediately froze all board activity, halted all pending fines, and specifically voided the illegal lien intent placed on my cabin. It was a complete and sudden legal asphyxiation of Patricia's authority. The true legal bombshell, however, was reserved for the second phase. Based on my discovery of the technical flaw in the original master declaration filing and the AG's own review of their arbitrary enforcement methods, the state filed a petition challenging the corporate standing of the entire association. They argued that the new board, under Patricia, had operated outside the bounds of their nonprofit mandate, effectively becoming a private tyranny rather than a cooperative community service. This wasn't about a dispute. It was about dissolving the structure of power itself. The community's reaction was profound. For months, dozens of other homeowners, many of them quiet, older couples who lacked the resources or temperament to fight, had been silently suffering their own private wars of attrition under Patricia. They were being fined for unapproved deck stain, for guest parking violations, and for allowing their children's toys to remain visible for more than 30 minutes. They hadn't dared to speak up, fearing the exact lien threats that had been launched against me. But when the state attorney general's office stepped in, the floodgates opened. Emails poured into Mr. Harrison's office, detailing years of petty harassment and financial intimidation. The one-man crusade against my pines and my door became a massive, consolidated class of grievances. The full weight of public and legal scrutiny crushed Patricia. The other board members, facing the prospect of personal financial liability and legal deposition, resigned immediately, distancing themselves entirely from the now toxic remnants of Patricia's rule. She was left alone, holding the empty corpse of her authority, her fury replaced by a desperate, panicked fear. There was no one left to defend the too dark cedar door or the necessity of clear-cutting the protected brush. Her fight dissolved into silence. The ultimate satisfaction was the restoration of the covenants to their original, benign purpose. Under the supervision of the state, an emergency community meeting was held. The motion to permanently revoke all aesthetic amendments passed unanimously. The homeowners voted to return to the simple, foundational rules: maintenance of common areas, road repair, and preserving property values through reasonable means, not through authoritarian micromanagement. I found myself, ironically, nominated to a temporary committee to help draft the new, simplified bylaws, a document of barely 10 pages, explicitly stating that native habitat was protected and encouraged. My victory was complete. The liens were formally discharged. The fines were permanently vacated. The sense of peace I had paid for, and nearly lost, returned to the cabin in the valley. I watched the sun set over the pines, the same pines Patricia had demanded be trimmed, and they looked more beautiful and defiant than ever. But the most significant long-term consequence was the fate of Patricia herself. She couldn't stay. She couldn't tolerate the loss of control, nor could she bear the silent, judgmental gaze of the neighbors she had terrorized, who now owed their freedom to the man she had tried to fine. A few months later, the realtor signs went up. She sold her impeccably manicured home, quietly, quickly, and at a substantial discount. The cost of her legal defense against the state, combined with the market taint of being the HOA villain, ensured her exit was a financial and emotional failure. She was exiled from the paradise she had tried to ruin. The lesson I learned, standing in the quiet of my reclaimed sanctuary, was this: petty tyranny thrives on silence and attrition. Most people lose the fight not because they are wrong, but because the cost of fighting is too high. Patricia assumed I would fold, that I would prioritize peace over justice. She assumed the vast, confusing bureaucracy of the system would protect her. But every threat, every illegal fine, and every unapproved action was a piece of paper that could be used against her. When a seemingly small power structure attempts to dictate your life, remember that they are almost always resting on a weak foundation of corporate rules and technical mandates. Document everything. Find the core structural flaw, and then, if the abuse is extreme enough, escalate past the small pond of neighborhood politics and bring in the ocean of real legal authority. Never let the person demanding conformity feel they are safe within their own rules. Because sometimes the person you are harassing over a few untrimmed trees is already sitting at the table, waiting for the state attorney general to arrive. And you never know who is listening. Are you currently battling a ridiculous, abusive HOA rule right now? Tell me the most absurd thing they've tried to fine you for, and what legal loophole you found to fight back.